SJC-13178 in the matter of an impounded case.
Attorney Krasner.
Thank you very much. May it please the court. Good morning. I'm Sherry Krasner here on behalf of Mother. Mother's argument here is very straightforward. It gives meaning to the words, the standards of Section 3 as they are used in Chapter 119, Section 26, and it seeks to harmonize Chapter 210 and Chapter 119 and actions in probate court and actions in the juvenile court. The argument is not inconsistent with adoption of cadence, the case DCF relies on primarily in its brief, or adoption of Jillian, the case Child points to, or adoption of Donald, an appeals court rescript case that I proactively brought up in my principal brief. The simple argument is this: if DCF asks a juvenile court judge to exercise her authority to terminate parental rights, DCF has to have custody of the child. The judge has wide latitude to do many things in juvenile court, but the simple—
So can I stop you there, counsel, and just
Please.
ask you to clarify what you mean by custody? Do you mean physical custody, legal custody, or both?
An award of custody by the juvenile court, the decision maker for the court, for the child. And clearly, in this case, grandmother was the custodian of the child. She was the one who could make decisions about his medical care, about the early intervention services he was receiving. DCF could not remove the child from that home unless and we know this from a care and protection of manual, unless DCF went back into court and asked that the child be removed. This was not a foster care placement. Paternal grandmother was the decision maker for this child.
Well, child's counsel relies on also plain express language. It says, chapter 119, section 26(4), a judge may dispense with the need for consent of any person named in section 2 of chapter 210 to the adoption, custody, guardianship, or other disposition of the child named therein, upon a finding that the child is in need of care or protection and that the best interest of the child will be served by such order. Why doesn't that provide the judge the express authority to do what he does here?
Because you need to read the entire statute. And why would the language in accordance with the standards of section 3 exist if it wasn't circling back?
The standards of section 3 are those, they aren't the provision you're relying, right? Those are the substantive standards, aren't they, for dispensing with consent to adoption, right?
No, respectfully, no. Those are the factors in section 3C, 210(3)(c) that a judge needs to apply, those 14 statutory factors. But what I'm saying is that in the sections 3A and 3B of section 210 talk about the department having custody of the child before requesting that a decree terminating. And this goes back.
This thing you're arguing, this one sentence, has the potential to be to deprive, judges of ability to create a permanent solution here. Under your proposal, these parents who are clearly, got all kinds of problems can continually revisit the guardianship, right? They can,
No,
they can challenge it at any point, right?
if there was only a finding of the child was in need of care or protection and no termination of parental rights. You are correct, Your Honor.
Well, but that's what you're arguing. You're saying that's what has to be here.
No, in this case, grandmother, the custodian of the child, she could have filed a petition. She could
I
have
understand she could have, but what you're saying here is that if she doesn't, these parents can revisit this at any point in time, and a judge cannot basically provide a permanent solution here which is against a lot of what we've said in Nancy and these other cases where we want to resolve this issue. I feel like and also, but anyway, I don't,
I'm just-
you're wrong. Yeah, go
I'm
ahead.
just saying that rules and statutes and the language in statutes exist for a reason.
Yeah,
and-
but
and
you,
this is
the
how it-
language, that's why the language I read you is so important, because it gives judges the ability to make sure that parents who are, whose rights should be terminated can be terminated, so that they don't sit around and undermine the system continually. You're relying on a guardian who doesn't know anything about sort of the consequences of not doing this to have to act to prevent this. But I'm not, go ahead.
I'm sorry. And the guardian or the custodian in this case, these parents, for all their problems, and my client, I'm not going to tell you that my client didn't have deficiencies, but she was consistently visiting with this child every single weekend for both Saturday and Sunday. That was happening.
If this had been a normal case, meaning that DCF had custody and brought this, there'd be absolutely no question that the judge would have the right to terminate, all their rights here, based on the facts we've got here. There'd just be no question. You've come up with a clever, and I'm not saying unsubstantiated, statutory interpretation, but this would be a clear case for termination of parental rights and dispensing with consent to adoption.
But again, what the custodian was planning on doing, what she testified in her very brief testimony, is that if this termination went through, that the parents were going to continue to see the child. She was going to change it from every weekend to every second weekend. And so this is the woman who's been taking care of this child. This is the woman who knows the child, knows the parents. And she is suggesting that these parents are not such a destabilizing force in the child's life that they should have no contact. I mean, when adoption happens, when a termination happens.
Counsel,
Go ahead.
I just have one question for you. If the paternal grandmother, who is the custodian, correct?
Correct.
If she had asked for a termination, you're saying that it was possible for her to do that, right?
Correct.
What standards would the judge apply in that context? Would they come from Section 3, or would the judge be precluded because the motion didn't come from DCF?
No, it would be the same factors. The two petitions would have been tried together. There would have been a care and protection petition, and there would have been another petition filed by the grandmother, either to adopt or either for a guardianship, and the same kind of decision that in a normal care and protection case would have occurred. And this is the same thing that used to happen in the probate courts.
I'm wondering how that's consistent with your argument. If Section 3 provides the factors, even when DCF doesn't file a motion, why can't the judge apply the factors just because of what, under 119?
Well, I'm just saying that statutory language, it's there for a reason. It matters. And
I understand that, but you're saying that the standards consistent with Section 3 don't apply because DCF did not file a motion. But if DCF doesn't file a motion and instead grandmother files a motion, you're saying those Section 3 factors do apply. And I'm wondering how that's consistent.
Because this, before juvenile court judges had the authority to terminate parental rights, there would be a proceeding in the juvenile court. There would be a finding that the child was in need of care and protection. Permanent custody would be awarded to the department, and then the department would go to probate court and file a petition to dispense with consent to adoption. And when the the statutes were amended to allow this to happen in the juvenile court. It seems to me that what the legislators were saying is it should happen in the same way that it happened when it happened in probate court, that the custodian of the child is the one who makes the request. And I don't see it as elevating form over substance. It's a way to harmonize the two statutes, that the person, if DCF couldn't even remove this child from the home without a court order, why should DCF be the one who is saying, Your Honor, terminate the rights? There's also an argument that the DCF makes in its brief that if my argument were to be adopted, that would discourage DCF from allowing third-party custodians to appointments of third-party custodians. And I would hope that this court finds that as offensive as I do. The third-party custodians almost always are family members or are people that have a teacher or someone who has a close personal relationship with the child. And they are presumably going to act in the best interest of the child, that they are going to be.
Could I interrupt you, because you just said the thing that bothers me the most. Let's just say, for instance, that at the root of both of these statutes is the best interests of the child.
Of course.
This isn't a judge who hasn't any experience with this mother and father. In fact, there was another child, an older child, that's part of the issue, right? That in some ways, perhaps maybe it imported some feelings about the other proceedings with the other child. So you've got this body of experience with this family. And why is it that if at root, what motivates all of the judges, either on the probate family or the juvenile court, in what is best for this child, why isn't this an appropriate exercise of the judge's discretion? He can't unsee what he already sees. He can't unknow what he already knows.
I would remind this court first respectfully of that wonderful footnote in Adoption of Luke, that although you can't ignore history, that each one of these cases has to be judged on its own merits. So I would say that there was another child, but this was a new child born several years later. And this case was
that there were a bunch of findings that support why the judge did what he did specifically with this child.
Well,
I mean, you mentioned that there was regular visits, but there was record evidence that the mother was nodding off, the father was disinterested. There were all of these things that pointed. I mean, I believe at some point the paternal grandmother said she had had enough of these two. So again, if all of these things were happening that were positive for this child in the paternal grandmother's custody, why isn't this okay?
In this case, adoption, the point of adoption or point of termination is to sever all relations between the child and the parent because it's in the child's best interest. But even from that limited testimony from grandmother, she wasn't going to sever all relations. The child was going to continue to see his parents twice a month for several hours each month. And with respect to the specific findings, Your Honor, there was 5 months of consistent weekend visits without any problems. There was one visit where mother appeared to be nodding off. And so no evidence that she was using, but she seemed to be tired, and grandmother terminated the visit. There was no scene, there were no problems. And again, my client was not indicating that that she couldn't care for the child at this time. She wasn't saying that. She knew that. But to take such a drastic step, both because of the statute and also because of the specific findings, and I would direct the court to the end of my brief and the factual errors that the judge did make, the clearly erroneous findings that he did make with respect to visits. And again, this grandmother was offering this child permanency and stability. That was her goal. That's what the parents wanted. And to say that that can only be done through a termination of parental rights is problematic. And again,
But we're not, but the question is, the judge didn't have to do it, but the judge decides that in the best interest of the child, the judge doesn't think it's in the best interest of the child to have these two parents with all their problems, still able to challenge the guardianship down the road, to come into court. He's decided that it's in the best interest of the child to terminate their rights. That's different than that he has to, but he's decided that's within his power. That's a very different thing. I don't see why
Yeah.
that.
And counsel, let me ask you another question.
Sure.
I'm sorry to interrupt, Justice Kafker, but how are you confident that in all circumstances, the guardian would be acting solely in the best interest of the child and not in the best interest of the guardian or the guardian's children in this case?
Well, if grandmother had filed an adoption petition, there would have been an adoption home study. So that could have revealed if there were any concerns or any motives. I'm not sure I fully understand the question, but there would have been a process to understand better about the guardian. And our record here is so limited. We don't even understand why grandmother was seeking guardianship and not adoption. There's that one sentence in the adoption plan: the plan for this child is guardianship with paternal grandmother. That's it. There's so little information in this case. I mean, from her limited testimony, she appears to have been providing good care. The parents wanted her to provide that care, but we're making this consequential decision that's going to matter for the rest of this child's life. We don't even know the husband who's living in the home with the grandmother. We don't know how old he is. We don't know his health. And yet we do know that he is the person who is providing the financial support for this child. So there's so much. I have my statutory argument that I'm making, but also the facts of this case are just, yes, there's some things out there that these parents have problems, but we know and the judge, more importantly, the judge knew so very little about what was going to happen to this child going forward, that it was error for the termination decree.
So if you have a situation, not this case, you have a situation where you have the grandmother is the guardian, and the grandmother has a heart of gold like my grandmother's, and you just wonderful. But the grandmother is also just the most forgiving person, and there's always the possibility of redemption. So she's letting in the mom and dad who are just really not helping the child thrive. As a matter of fact, getting in the way of that in a way that's really serious. Is DCF without any tools to be able to move for care and protection and address that issue?
Of course not. DCF could have removed the child from that home, placed him in another home, and DCF would have obtained custody, and then DCF could have petitioned for termination of rights and could have proposed grandmother as the adoptive parent. They could have asked the court, if grandmother qualified as a foster parent, to have her be the foster parent.
But what if she's not the right choice anyway, because of her concern and empathy for her own child? And do we have to go? What's the process? How much delay is involved? Because we're concerned about delay in the juvenile court.
Absolutely, as you should be. But on the particular facts of this case, this case had only been in the system for 7 months when the trial happened. And I know 7 months is a long time on some level, but in terms of how other cases proceed in the juvenile court, 7 months is not that long. And the court knows from the factors in 3C that it's 15 of the last 22 months that is the trigger that our legislators have determined. This is when you really have to make those determinations. So we were well before that in this particular case. And again, there would have been other options for this grandmother if she wanted to adopt a child. Again, she could have filed her own petition. And then admittedly, we wouldn't be here, or possibly we wouldn't be here. I might still be making the argument about the facts that aren't supported by the record, the very slim record, but the statutory
Counsel,
argument.
can I ask you one more statutory question, which is that the statute says the child is in the care or custody of DCF, and you've addressed the custody part. Is there anything to the or?
Right, the care, I believe that circles back to section 23 of 119, that there are other ways that children get into the system through voluntary requests by parents, through a sua sponte order in the probate court. I think.
And it's your position that this child was neither in the care nor in the custody?
That is correct. There was an ex parte hearing, non-adversarial ex parte hearing at the time of the child's birth. And then at the next court hearing, an award of third-party custody was made to the paternal grandmother.
So are you saying if DCF really thought that this was the way to go, in order to do it, they would have had to remove the child from the grandmother's custody first and retake custody and then do what they did?
Correct. Or I mean, we don't know again from this record if grandmother would have qualified as a foster parent, if she met the requirements in terms of her background, her home, the standards that DCF looks to approve someone as a foster parent, or the child could have been placed in another home, but still with the proposed adoptive or guardianship resource as the paternal grandmother. And I'm not trying to make things harder for judges in the juvenile court. They have busy caseloads, they have a lot to do, but I am saying they need to go.
You're removing their flexibility, which we've stressed tremendously, that they have great flexibility in the arrangements they agree to in the best interest of the child. And we've said that in the context, you say Chauncey and the other cases, I can't remember, but there are a bunch of them where we emphasize that flexibility. Cadence, Jillian, guardianship of VV. I mean, we've done this a bunch of times, but you're limiting the flexibility dramatically.
But no, I believe not, Your Honor. Only in that very narrow circumstance where a third-party custodian is the custodian of the child and not the department. And I don't have the numbers for the court, but I can tell you that we're not talking about many, many cases. And again, third-party custodians generally as family members familiar with the child. And the whole reason that the department isn't required to file those petitions for termination when a child is not in foster care. We don't want children in foster care to linger. That we all can agree upon that, but there can be different paths when a child is being taken care of by a family member. And not trying to prolong the process, not trying to make the process more difficult, but just saying it's a little different way to get to permanency and stability for a child. And in this case, the judge didn't have that authority because it was one of those sort of different cases. And DCF didn't have custody. Grandmother, the custodian, didn't file her own action. And it should be cleaned up, and it should be cleaned up for all cases in the future.
Thank you very much.
Thank you.
Attorney Kernan.
Good morning, Your Honors. May it please the court. Jennifer Kernan for the Department of Children and Families. The department is asking this court to affirm the decrees and judgments of the court below, terminating mother and father's parental rights. This is a case where the parents did not contest unfitness, and the parents actually urged the court to approve the plan of guardianship with the grandmother and supported the child being with the grandmother permanently. The issue before the court is whether the judge had authority to terminate parental rights when the child was not in the department's custody. And
So
here,
how do we get around the statutory language?
the statutory language does not preclude this scenario from happening, specifically because this was a petition that was filed under 119. There is a distinction in 210.3 paragraph B between petitions filed under 210.3 and petitions filed under 119. And because this was a petition filed under 119, custody is not a requirement or a prerequisite rather for the department to seek termination of parental rights.
I'm confused by that because, I mean, I get why a judge should retain flexibility, but I don't understand why why the department, once the department is not, it doesn't have custody, why they should be the ones driving, why they, especially the department has a history. They always want to get the parents out of the way. So I understand when they actually have responsibility that they can do that. I'm confused though when the guardian has responsibility, why the department should be the one pushing that, and especially when the statute says the opposite. That to me doesn't mean that the judge can't on his or her own do it. But I'm perplexed why the department should be given a right to weigh in like this when they don't have custody. I get it. I'm very uncomfortable with eliminating the judge's discretion to do it unless the statute precludes it. I don't see why you get to do it when the statute says the opposite.
I think there are sort of two answers to that question. First is that in adoption of cadence, the ability to terminate doesn't require that anybody proposed or supported the termination of the ultimate custody order. So that's part of the answer. And then the second part of the answer is that the department is the petitioner. The department is the one who initiated this action. And because it was initiated under 119, the trial judge is afforded the full panoply of rights or options under 119, and that includes termination of parental rights. And the ultimate objective is achieving permanence for this child, and that permanency is going to be what's in the best interest of the child. And the department is the agency charged with promoting child welfare. And this is, at this stage, at the trial stage, the department was still involved. Again, the department was the petitioner. We're still involved in sort of prosecuting this care and protection. We have an interest in making sure that the child achieves stability and permanency, and that the outcome that's achieved is in the furtherance of the best interest of the child. So in that regard, the department has an interest and is still a player in the outcome. And that's why sorry, did somebody have a question? No. That's why the department is able, pursuant to 119, to request termination regardless of custody status of the child. Additionally,
Hey, can you help us? Walk us. I think it would be useful if you do a little more close reading of the text that the counsel for the mother relies on. How do you make that language go away? I'm still not sure I understand how you do it.
You don't make that language go away, but because there are multiple paragraphs in section B. I think it's the first paragraph that contains the language regarding custody, and that paragraph deals with petitions filed under 210.3. The later paragraph I think it's a third or fourth paragraph, deals with petitions filed under 119.24, and that's where we are with this case. Prior to the
So
19.
what's the difference between those two filings?
So prior to
What's
the
the difference between a 119 and a 210 filing?
The 119 filing doesn't necessarily start out as a request to terminate. Prior to the 1992 amendments, the care and protection petition would be filed in the district court or juvenile court, seeking temporary custody of the child and even permanent custody. But before 1992, if the department wanted to dispense with the need for parental consent to the adoption of the child, the department or whoever had care or custody of the child needed to file a separate action in the probate court. And that action was filed under 210-3. The 1992 amendments wanted to sort of streamline that process and avoid any undue delays when the child's best interest warrants a fair and prompt resolution. So because of the 1992 amendments, the district and juvenile courts were given, or the authority was extended to the juvenile and district courts to make the same type of determinations that had previously only been allowed in 210-3 petitions without having to go file a separate petition. And that language, the language in 119.26 that refers back to the standards in 210-3 sort of made everything all on a level playing field, if you will, so that a judge considering a 119 action and a judge considering a 210 action weren't looking at different factors, weren't looking at different things. They were considering fitness and using the factors in 210-3C as a guide. So because this petition, the current petition before the court, was filed under 119-24, custody per the statute is not required in order for the department to seek termination. And on top of that, the notice that a parent receives when a petition under 119 is filed includes notice that their parental rights may be terminated. One of the things that Mother mentioned in her argument is that this would be okay, this scenario would be okay if the guardian had filed or had sought termination. And Mother described two separate petitions being filed, but that's the exact thing that the legislator wanted to avoid in making the 1992 statutory amendments that created or gave the juvenile and district courts that broader authority to do essentially the same thing what the probate court could only do before the 1992 amendments. Additionally, this court has stated that the standards described in 210-3 is the best interest standard. And in furtherance of the best interest standard, it would make sense to allow the department to seek termination even if the department does not have custody. And that's something.
Can I interrupt you, Chief? I know council's over time, if you wouldn't mind. So, council, one of the things that bothers me about this is you keep making reference to that the department could do this, but the department didn't do this. The judge did this sua sponte, right? And I understand in the record, there's the summons to the mother, and it includes all of the language that you just told me that they could terminate her parental rights, but people don't really read that. The issue that I'm having is the mother is walking into court, accepting her limitations and the fact that this is the best thing is to give paternal grandmother custody of her child, to give that child the best opportunity to lead a good life. That's what they walked into court to do. And that's not what happened. Because in there has to be baked in the hope that perhaps she can get a hold of some of her substance use disorders and some of the other things that maybe are keeping her from being the mother that perhaps she'd like to be, that there's still the hope that you could do that. And shouldn't we hope for that? Isn't that something the department wants to see happen? And how could that happen if you go in hoping that paternal grandmother's giving permanent legal guardianship, but you walk out saying, you know, I have no longer any parental rights?
I have 3 points to make in response to that question, if I may continue. I know my time is over. First, it was not a sua sponte termination. The department did file a notice of intent, basically putting people on notice that the department was seeking termination. And second, Your Honor has referenced the fact that the parents walked in here, but they actually didn't. They didn't appear at the trial dates, either trial date, and they didn't appear at some of the previous court dates. Third, Your Honor mentions giving the parents a chance, giving the parents a hope. And yes, it would be ideal if the parents were able to sort of conquer their shortcomings. And that's what engagement with the department is designed to do. The department creates these service plans as guides to help the parents overcome their parental deficits. However, here, neither parent engaged with the department in any way whatsoever. And this is not the first, mother's first engagement with the court and with the department. And if there is going to be hope that the parent might become fit, it has to be more than a faint hope, more than just a mere hope. And that hope cannot be at the expense of the child's permanency and stability. And for those reasons, the department requests that this court affirm the judgment and decrees of the lower court.
Thank you very much. Attorney Taylor.
Yes, good morning. Susan Taylor for the appellee child. The appellee child supports the affirming of the trial court's termination of parental rights in this case. Excuse me. I think it's important to know that my client came into care when he was a newborn in the hospital. He had been drug exposed, and there was a care and protection that was filed in the Fall River Juvenile Court. And the parties to that particular action were the department, the mother, the father, and the child. All of those parties were represented by counsel. And at the 72-hour hearing, there was an agreement, a stipulation, that the third-party custody would go to the grandmother. And I think it's important to realize that that custody is not a permanent custody. It's a temporary order made by the trial court. The fact that they entered into the stipulation didn't render the care and protection moot. It was an ongoing petition. So at that point, it's not as if because the grandmother had custody that the department was no longer a party. They weren't stricken from the action. And the grandmother is not added as a party to the action. So basically you have a temporary order of custody, and it's conditional custody. It's custody that requires the grandmother to act with the cooperation and under the supervision of the Department of Child and Family. Now, when the case ultimately, and it should be pointed out too, that although grandmother had a right to come to the trial and basically testify about the progress of the child in her care, she didn't have the final say. So when the case came to trial, when it was on for the hearing of the merits, and this is some 7 months later, and during those 7 months, the parents don't participate in any kind of action or service plan, which would have basically alleviated the concerns to which the child was originally brought to the attention of the court. The mental health concerns, the addiction concerns. It was concerns that had not only for this child, but for another child that rights as to that child had been terminated. So when the case comes to trial, and there's a hearing on the merits, a trial that not only did mother and father not appear, but mother's counsel stipulated that mother was unfit and advocated to the court that the court should adopt the permanency plan of permanency through guardianship. At that point, the court had the authority to evaluate, number one, whether or not the parents were fit, and was the termination, and nowhere in any of the statutes does it ever talk about the termination of parental rights. They refer to it as dispensing with parental consent for adoption. So in this particular case, the trial judge determines, number one, that mother is unfit, and two, that it is in the best interest of the child that he be placed permanently with this guardian and that parental rights be terminated. And he expressly says that he has concerns that he doesn't want these particular parents to be able to continually re-enter this child's life. These decisions should now, and it's at that point that the case is concluded.
Can I ask Ms. Taylor, because I get all of that. Could you help us just with the pure statutory, the sentence that Ms. Krasner is focused on? Can you help us understand? Because I understood the Attorney General's office, but I'll be honest, if you could simplify it a little, it would be useful for me.
I would suggest that, and the way that I look at it is up until 1992, only the probate court had the authority to terminate parental rights. And you could have a collateral or ancillary care and protection that took place in the juvenile court. But at that time, the juvenile court was not empowered to terminate parental rights. So they could come into the probate court under 210, and they would call it doing a 210 in order to terminate parental rights. But when the statute was amended in 1992, at that point, the juvenile court under 119 section 26 empowered the juvenile judge to make that. And what's particularly important is even if the department had not moved to terminate parental rights in this case, the court could have done it sua sponte under the statute, under the express language of the statute, as well as under the case, I think it's adoption of Donald that talks about that. In this case.
Ms. Taylor, though, over here. I understand your argument as to what determination was made, and I understand your answer to Justice Kafker's question about the legislative intent. But if we could just go to the actual language of 3B, because we need to look at what language we're applying that legislative intent to. So if I could just ask the same question Justice Kafker asked, could you point to why the language in 3B does not mean that if the child is not in DCF's custody, they can't be the petitioner?
What I would suggest to the court is that the language, the reference to 210 section 3 is basically a relic of the fact that those were the substantive considerations that a judge would have to consider in order to dispense with parental consent for adoption. I don't think that the two statutes read side by side conflict, because the plain language of chapter 119 empowers the juvenile court to take that step. And the judge in this particular case, that was the only issue in this case. And the trial counsel for mother teed this up exactly that way. And the trial judge in this case said, I understand all that, but under chapter 119, I am empowered to determine whether the parents are unfit and whether the child's best interest is served by termination and adoption and or guardianship. The judge expressly says that I am empowered under this statute. So it's the fact that the department is involved. I mean, they are at the temporary custody hearing where there's a stipulation, and the stipulation is in volume 1 of the appellant's exhibits, and it's at page 80. And if you look at that, all of those the court didn't give grandmother custody. He gave her conditional custody as a temporary order while this case was pending. And given these circumstances, I mean, all of the circumstances in this case, on behalf of my client, who is now 2.5 years old, he is entitled to permanency. He's been with his grandmother for his entire life. The parents have never established that they would ever be fit, and the judge did the appropriate thing in terminating parental rights and creating a guardianship with the grandmother.